Good morning. Good morning and welcome. My name is Gabrielle Goodwin, and I'm the Director of Graduate Legal Studies and a professor at Indiana University Maurer School of Law. And it's an honor for Indiana University Maurer School of Law to sponsor this brunch program this morning, which, after being tortured by this problem day and night for months now, gives you a unique opportunity to hear from the authors and even ask them questions. As the director of the program at Indiana University, which includes the Masters of Law program, the LLM program, I travel to law schools all over the world, meeting with students, faculty, and alumni. And over the last few months, in every country I visited, I watched as students struggled with and prepared for this year's competition, trying to make sense of a complex problem concerning the interpretation of a peace treaty, deadly attacks in allegedly occupied territory, unilateral economic sanctions, and the legal consequences of failing to dispose of hazardous plastic waste. And what I couldn't tell them, and the reason why Indiana University Maurer School of Law is especially thrilled to be part of this year's Jessup, is because one of the authors is our very own Professor Asaf Lubin, whose area of expertise include public and private international law, cybersecurity and national security law, and international human rights and humanitarian law. Professor Lubin is one of many professors at the Maurer School of Law whose work includes and promotes an international law perspective. In fact, the LLM program offers a number of specializations where students can choose to focus their studies on international law and how international law intersects with other subjects, such as cybersecurity, information privacy, intellectual property, financial regulation and capital markets, business and commercial law. Moreover, students who complete the LLM program may be eligible to sit for a bar exam in the United States, and we have many alums who are now practicing attorneys in the country. So much like the Jessup competition, which is a one-of-a-kind experience that nurtures students' interests and prepares them to engage with the global legal profession, the LLM program at Maurer also is unique to allow students to choose their own path, fully supported by a world-class and globally engaged law school. To learn more about our programs, we invite you to pick up a brochure on the table in the back, as well as a number of goodies there, and my business card if you want to ever reach out. Now, as we wait to discover what the future of the Clarent belt will hold, I'll excuse myself and cede the floor to Steven Schneebaum, member of the board and chair-elect of the International Law Student Association and the MC of today's panel. Thank you very much.
Well, thank you very much, and thank you to the Indiana University Maurer School of Law for sponsoring this event this morning. It is, as you were just told, a unique opportunity to meet and to interrogate the people who were responsible for torturing you over the last 6 months. Or maybe the people who actually taught you a lot of international law over the last 6 months, or perhaps both. So without further ado, I'm going to introduce the two co-authors of the 2023 Jessup Statement of Agreed Facts. You have already heard about Professor Asaf Lubin, who is a longtime friend of the Jessup competition. This is not his first rodeo. He has written at least one other Jessup problem over the last several years. And Shannon Kisch, who is an international lawyer and particularly an expert in international environmental law in Israel. And the two of them communicated with the executive office, with ILSA, with the editorial board by Zoom. It was not easy, but I think you will all agree, at least I hope you will all agree, that the work product that emerged from that process was something very challenging, meaningful, and we hope educational. So I'm going to ask the two authors to make some introductory remarks, and then it's up to you to ask them such questions as, why in the world did you do that in QP2? Or where in the world did you get the names from? Or any of those questions, ranging probably from the sublime to the ridiculous, but all of them will be very welcome. So, Shannon, take it away.
Hi. Good morning, everyone. Thank you for the introduction. So a little bit just about me. As said, I practice environmental law, chiefly in international law in Israel. My background is a little bit varied, which sort of comes up in some of the more quaint details of the problem. I had about 10 years education and experience in theater, specifically Shakespearean theater, before I ever got into the law. And that has carried through somewhat. We wanted to I'm going to talk a little bit before we get into questions and answers about the process that we had, and Asaf's going to talk a little bit about some of the initial law issues which we see maybe coming up. So regarding the process, this is actually, we had some people asking, so how long have you been working on this problem? And when we say, the writing was about a 4-month process, but we've actually been communicating on this for about 4 years. Asaf and I started working on a proposal in 2019. And submitted multiple times. We were talking about it today. We don't actually really remember the layout of the original problem we suggested. The only thing, there's something which is carried throughout, which is the name of one particular person in the problem, which is Dan Vortigern. He somehow has survived through all of it.
We called him Vorty.
Vorty, yeah. And so year after year we applied and we were not accepted, but they said, but we really sort of liked your proposal, so please submit again. And us being stubborn, and we decided, okay, yes, we're going for it again. And we sort of tried to look at additional, sort of preserve some sort of framework while going through. We were communicating and working on 2 different continents at the time, and one big advantage of that is that there's never a time when somebody isn't working. So the problem basically never slept. I think we had something like 17 different iterations going back and forth, which you may ask about at some point during the question and answer session. So that just basically about how we started the work process, how we got here, and as we said, working over Zoom, and maybe difficult, but also really delightful to sort of have these conversations virtually, and then get here, meet the people who are in charge, get to see all of you both, during your sessions and out of them. So that's just as a start.
So, good morning. This is really, really terrific moment. For me in particular, because it's a closure. So the last time I sat on this exact podium was in 2016, when I wrote the Frost Files case. And at the time I was, yes, Frost lives on. At the time I was an SJD student, a doctoral student. And to come here now as a law professor, to have Indiana University Maurer School of Law sponsor the event, the school where I teach, it's just a really great honor for me. It's particularly a great honor to do so next to Shannon Kisch. So one thing people don't know is that when the problem in 2016 was written, while I'm written as the sole author, Shannon Kisch was in the background of all of it. Because it's really hard to write these problems, and certainly as a single author, it's really hard to write them. You have a back and forth with a large group of editorial members, Steven Schneebaum being one of them, for both the 2016 problem and now for the 2023 one. And you don't always like what the editors tell you, and finding ways to engage with your feelings in a productive manner requires a team. In both processes, I can tell you that Jessup, both in the inside of it and the outside of it, is a wonderful community of people. I know you've only seen us as judges in rooms where we often ask you hard questions and you're unhappy about. But in that judge's room lie some of the nicest, kindest, and most smart people I've ever met. And so we encourage you to come back because we encourage you to be part of that very community too. But I also recognize that this is about you asking us questions. So let me begin by referring to you as Your Excellency. And then let me also use my favorite phrase of all time in Jessup, I understand your concern. So I do understand your many concerns with this year's Jessup problem. I will say two things about it and then leave it to our discussions. Point one is that this year's Jessup problem is dense. It is multiple Jessup problems wrapped into one. In fact, that's one of our fellow judges, Andrew Holmes. He told me the pleading one could have been broken down into 3 different pleadings. Now, I'll tell you that my personal preference, I think both of our preference, is a wider net of issues. It's not the only approach to doing Jessup. Jessup can be narrow and therefore more in-depth on every topic. In the wider scenario, what you get is the opportunity to engage in a large universe of legal arguments, but then to strategically choose what you come into the room with, because you cannot bring everything because there's just too much. And that act of strategic concession is such an important skill in a courtroom that I really valued. And I think that some of you demonstrated beautifully how you choose to kill a particular argument, focus the discussion, the dispute on another one. I think that is an important skill that you want to take with you. The only other thing I want to talk about is the unsung hero in this year's problem, which is Balan. I don't know if you're all familiar. There's something called the Third World Approaches to International Law, 12 critiques of international law. And the idea is that we're criticizing international law institutions who might use the language of justice and equality, but really by what they're doing either directly or indirectly is entrenching inequality and entrenching power imbalances. And that critique has at times been raised against moot court competitions too, that they too are not there to do the job of providing good education, but rather they are entrenching certain legal arguments for the next generation of lawyers. And it's especially in that context that I want to talk about the fact that the victim state is not a party to the dispute. At first instance, that might look to you as if, here again, we're silencing the unvoiced. So I want to say a couple things on that. Writing this year's problem in the midst of everything that is ongoing in the situation in Ukraine was a very hard deal. A member of the editorial committee was a Ukrainian friend of the Jessup, and that was precisely to ensure that what we're doing in creating this year's problem was not to further entrench the feelings and frustrations that so many of our community have about the ongoing horrors in Ukraine. And so choosing to separate from the victim state allows us to separate some of that possible feelings of anxiety that I think many in the community shared when the topics were first released last year. So that's one. The other thing that I'll note is that the original problem didn't have sanctions in it at all. It was a request that we were given by the then board and later the editorial committee to incorporate a sanctions problem. And we couldn't find a way of doing a sanctions problem without making it a trilateral environment. Because if the victim is the one levying the sanctions, it just doesn't carry the same legal effect as if a third-party countermeasure is being introduced. And so that entailed, again, putting Balan in a different place. I don't know if we landed on the right balance. I will welcome your thoughts on that. But you should know that every single aspect of this problem, including this one, was given great amount of thought and detail throughout the months leading up to this. And with that, I turn it back to Steven to take us through.
And let me just say before I open the floor that I've served on the editorial committee for years and years and years. And one of the issues that we always confront is the sensitivity of the authors, who sometimes are resistant to the idea that their favorite part of the compromise or the problem just doesn't work, or that something else is introduced that was not their brainchild. These particular authors were among the easiest to work with that the editorial committee has ever confronted. Asaf and Shannon both understand the process. They were willing participants in it. And you can hear from both of them right now the depth of thought that went into even the smallest details of the problem that you have all been living with for the last 6 months. So, with that, I understand we have only one handheld mic, and so to avoid our bailiff having to run back and forth across the room, I'm going to ask people who want to ask questions or make comments to line up in the aisle here, stage left, so you're right, and the handheld mic will be given to you to ask your question or to make your comment, and we'll see how the authors respond.
So please come to the front.
Come
to the front.
come into that aisle. There you go. Okay.
Well, so I can do it right now, right? Well, our first question concerns whether immunity is really a core issue in our present case. Because we can see there are central banks, high officials, but we find that nobody cares about it. Even the judges don't care about it. So have you ever come to your mind that immunity may be an issue here?
So are you referring to sovereign immunity for the sanctions issue?
No, this immunity for the head of states and the sovereign immunity for the central bank. Because we can see in paragraph 53, there are those issues, but we never encounter it.
Yeah. So immunity comes up in the third pleading across different dimensions, as you see, both in the sovereign immunity over the property, say the central bank, as well as the immunity of particular individuals, say the head of state in this context. I'll be honest with you and brief. It's not in the bench memorandum, so we weren't expecting significant analysis of it. There's a mention of it in the context of the legality or illegality of confiscation. I know that the Iranian assets decision that came out talks about immunity, again, more in the sovereign immunity context. So a question, I'm going to intercept the question that might come. We did not plan this to match up with the Iranian assets decision, nor did we produce any commentary on the Iranian asset decision because we felt like the majority of that decision dealt with the specific language of the Treaty of Amity, and we didn't feel it had too much of a hold on this year's case. So my short answer to you is that you were right. The judges were not asking you questions about it because it was not in the bench memorandum.
And our second question concerns why do you stuff too many things in the sanction part? Because we have roughly 4 different types of sanctions and we have to deal with them respectively. So why do we stuff too many things in that? It is a lot, to be honest.
So you go. No. So the sanctions were modeled on, mind you that this was written in April, May, June of last year, so in the first few months of the start of the Russia-Ukraine war. And while the sanctions go beyond Russia-Ukraine, as you beautifully demonstrated with your wonderful examples of state practice around unilateral sanctions, it is true that we modeled the sanctions on some of the ongoings in the Russia-Ukraine scenario. And there was just a lot of sanctions being levied at the time. And we wanted students to be able to engage with a disproportionality claim or a claim around reversibility if you talk about countermeasures legality. And the only way you do that is if you introduce enough oomph for that to feel bad. But I'll tell you, the people in the judges' room, like, the sanctions is silly. Of course it's lawful. There's no question it's unlawful. And so the fact that you're saying that we had too many sanctions is maybe our way of responding to some people who just thought, no, this is not a legal issue that has a lot of merit.
And that being said, also, if you look at the problem now, again, as compared to earlier versions, the sanctions are far, far less broad than they were originally because we had a considerable amount of consultation with various experts who said, well, if you put this in, you're going to get into even deeper problems than you're already. So we actually cut them down quite a bit before we released the problem to you.
Good morning. I wonder if you could enlighten us as to whether this problem was written to favor or disfavor the application of additional Protocol 1 to the conflict in this case.
You're not holding back there. This is a live issue for international lawyers and for certain countries, whether AP1 and AP2 are reflective of custom and whether they're binding. In some respect, we avoided all of that by making the parties party to AP1 and AP2, and so we didn't need to get into the weeds of that debate. I will also note to you that my personal belief, reflective in the ICRC's customary guidance on international humanitarian law, is that these rules are customary and binding on all states. And so here I disagree with the United States, who has taken a strong position, and by the way, Israel, we're both from Israel, who has taken strong position on AP1 and AP2 not having that customary effect. I also think that the model of relying on military manuals, which we heard a lot of teams doing a great job of opening literal manuals, quoting from those manuals, especially, for example, one of my favorite topics, espionage and intelligence, in analyzing what is sufficient intelligence, going to manuals of multiple countries. I thought that that was really effective.
If I may follow up,
Please.
maybe I could be more specific.
Yes.
Can the court decide whether this is or is not a war of liberation,
I see.
or in some other way challenge the statement of the UAC that it is?
That's a great question. Okay, so now I understand where you're coming from. So let me tell you the history of the Article 96 incorporation into the clarifications and corrections. It was not there in the original drafts, and it came from you.
Yep.
A student team sent us a question asking us, was there an Article 96 declaration? Now, I'll be honest, I never heard of an Article 96 declaration. And so I immediately rushed to read AP1. What is this Article 96? And then we came up with that entire history that you all found too, about multiple entities requesting the depository, the Swiss depository, to recognize them under Article 96, being rejected over and over again, except for that one incident that you all correctly cited. And so what we were doing with that is that predominantly we wanted to internationalize the conflict. I know that there's people in the room who are very unhappy with what I'm about to say, because they fought on and died on the hill of this being a non-international armed conflict. We hoped to internationalize the conflict to solidify the applicability of AP1 in that sense. So it was, to your original question, it was about favoring AP1, because we hoped that that could narrow the scope of dispute on pleading 2 around the POWs. Of course it didn't, and you still found creative ways of arguing around that. The last thing I'll just say is that depositories, and I ask this question over and over and around, depositories are notorious for being sophisticated mailboxes. Their primary job is just to transfer documents. And so a good pushback on really is the Swiss capable of legalizing the status of the UAC was that it's not for, Ragnall is not to succumb to whatever the Swiss say in their acceptance of the document, but we heard interesting arguments all around.
Please.
Hello, my name is Nick Yurlov. I'm the coach of Yaroslav the Wise National Law University from Kharkiv, Ukraine, and I have 2 points to make. First of all, I would like to express my sincere gratitude for the problem. I cannot imagine how much discussions you went through, and just a point of observation. So every 7 years, my university wins the national rounds. Every 7 years we come to DC, and every 7 years Asaf Lubin is the author.
So see you in 2030?
And that's the first point. That leads me to my next argument, Your Excellency. First of all, as I began reading the problem and I see 3 or maybe 4 issues cramped into one, and one issue completely unrelated to the 3 other, that's very Lublin-esque. Thank you. I had the gut feeling, but on the importance of IHL. So I've been doing IHL for the past 9 years, since the start of the Russia-Ukraine war in 2014, and especially advising the armed forces of Ukraine since 2022 invasion, and the questions of targeting and choosing the proportionate measure weapon and taking precautions in attack and defense is a very, very big problem, especially in urban warfare, given that there is lack of clear guidance even from ICRC and other organizations such as Geneva Call. So thank you once again for bringing up for getting the students on to work on developing the particular guidance. This is very important for us. Thank you very much. Now, second point, and here's a question related to QP1. Is there really a standing on behalf of Aglavale to submit the violations, alleged violations of the treatment of prisoners of war? And is it really reasonable to claim that evacuating the POWs from the active war zone is a violation? Thank you.
So, first of all, thank you so much for those kind words. I will note that when I participated for the first time in 2011, that was the drone year in Jessup. So that's, I loved it. And Jessup had played around with IHL in a couple years following, but coming back to IHL as a core issue, I think was really helpful in a time where IHL is routinely being disregarded around the world, not just in the Russia-Ukraine context. To your specific point on standing, I'll say this. First of all, the language of Article whatever of the peace treaty, the 40, you will know 41. It better than I do. 41, thank you. There we go. The language of Article 41 echoes the peace treaty of Versailles, and it is supposed to harken back to a PCIJ case. Names now elude me. Wimbledon, thank you. Yeah, and so if you go back to those cases, you'll see some of the discussion of the court on the ability to rely on that open-ended language around every party to the treaty may bring a claim. So that's the context. And by the way, kudos to Peter Zeng. He was the one who recommended the incorporation of that language into the problem. I think that there was good, interesting debate around standing in this context, around erga omnes and erga omnes partis. That's certainly what we hoped will happen, and that's what we saw in the rounds. I think that there's good reason to push back on just a quick application of erga omnes partis using the relevant case law of the ICJ, given that this is a really weird treaty compared to the treaties in which erga omnes partis was previously opined. It's not a multilateral, it's a trilateral treaty. It's not about genocide or discrimination or whatever, some broader fundamental human rights about just the territorial relations between these parties. And so it was a live issue, and I'm not here to solve the problem because we don't have answers, we just have the legal debates for you.
Thank you so much for sharing all the insights. My friend and me are quite interested in the drafting process, and we have seen from the discussion that there are a lot of communication, even intervention going on from the drafting committee to the authors. So we would like to know, how different is your original, submitted version of proposal in March last year, and the final product we started today, and what are the techniques that you see as very helpful in the way that integrate all those suggestions and edits? Thank you.
Well, thank you for the question. The problem as it was originally proposed way back in March and January of last year is unrecognizable from the problem that you see now. As Asaf mentioned, just the specific sensitivities around world issues this year necessitated making some pretty substantive changes in the problem as originally set. Despite the fact that, again, this problem had been several years in the making, and we never thought when we originally started proposing some of these issues that they would ever be problematic. So sitting down, and first of all, as we said, there was a special committee saying, okay, these are the world issues happening right now. How can we make this problem one which will be an experience for the students which is educational, non-confrontational, and an attempt to incorporate the principles of the Jessup competition in terms of fostering comfortableness also for the students in approaching these legal issues. So there was a committee set up for these are the issues that we feel actually should be set forward. So that was first of all. And then Asaf and I started setting out on the writing process, and basically what we ended up doing was we ping-ponged back and forth. We would write a version, send it back, and a couple of days later send a different one. And that was all before we got to the committee. Then we sent it off to the committee, and the committee was like, Well, essentially, this legal issue is completely wrongly stated. Stephen was especially adamant on certain elements having to do with the sanctions. Politely, absolutely, on the sanctions issues, because each of the members of the editorial committee is chosen because of a specific expertise in an area of international law. So everybody had their comments, and aren't you aware of this particular source of international law? Why, no, we hadn't actually taken that into account when we were writing the problem. So you better go back and read some more over that. And, and that was how it began evolving. And there was constant back and forth. The problem never had a rest in between April and September when it was issued. It was maybe the last 2 weeks when we sort of got into the fine nitty-gritty of the tuning. Up to then, there was a lot of tuning of the legal issues of the specific word. As you can see, what ended up showing up in the problem was a version which came out at the beginning of August. Yeah, and I don't know if you've, we know that there were a number of students who had many heart attacks when the judges started opening up the program to refer to the problem, and they're justifiably so because the differences are extreme. And again, they all had to do with very specific targeted issues, which would have made the problem even more dense and more difficult to sort of parse out than it was at present. So I hope that answers. Yeah.
Please.
Good morning. Just as this gentleman has said, before the declarations, we didn't know that there was before the clarifications, we didn't know that there was a clarification of the UAC, and I think it did bring us trouble. I think everyone in this room will agree with that. But before the clarifications, there is a reason to consider this conflict as a non-international armed conflict. And I mainly researched on the second issue. I think in a non-international armed conflict, we had customary law concerning the forced labor, but concerning the detention and deportation or evacuation, I think if I was right, there was a vacuum. And I'm wondering if this was Your Excellency's concern, or is it just I went the wrong way? Because according to the materials you provided, there are 2 essays concerning the deportation and detention in non-international armed conflict. So I was just wondering what Your Excellencies think. Okay, thank you.
Yeah. That's a great question. So as we've already discussed, pleading 1 is a very long pleading. And the worry that we had, it's often the case that the first speaker argues pleadings 1 and 2, is that if we kept pleading 1 as we did, and we wanted to keep pleading 1 because we wanted jus ad bellum and jus in bello, we wanted the interplay between jus ad bellum and jus in bello, and we also, within jus in bello, wanted 2 versions of attacks. One attack that is intended to cause the harm, one attack that is unintentional in terms of the harm that it produces. So we kept pleading 1 mostly intact, and then the worry was, well, now pleading 2, you need to prove that it's occupied or non-occupied territory. You need to address the legality of detaining them in a penitentiary. You need to address the legality of putting them outside of the occupied territory, and you need to address the legality of their enforced labor. That's a lot of things. So that's why I started by apologizing. It's a very dense problem. But the idea of trying to push you in the direction of internationalizing the conflict was to narrow the scope of dispute for pleading 2 to give you some breathing room. So if you're able to not fight, and many teams, including Regnellian teams, conceded. We're conceding. This is an international armed conflict, and this is a POW status, and then zoomed in on an application of POW without getting into the weeds of what applies in NIACs and how do we apply it to NIAC. So that was the core logic there when we did that.
Although we will say that when we started the problem, way back at the beginning of the process, one of the things I remember, we had a conversation, we were thinking, and this is also in earlier versions, this has to have something to do with occupation. You were very much involved about the idea.
This is the first Jessup problem in the history. You can open, because the Hein Online compendium provides it. The first Jessup problem to deal with occupation law. And that was a priority of ours. And so we wanted occupation to be in there for sure. Yeah.
Please.
I was actually wondering, since you spelled out the name of the UAC in Balani, where did that name come from? Since I was searching for it and I could not find the reference. And also, did the UAC only receive masks and gloves for cleaning up the waste? What was the actual equipment?
Can you repeat the second question?
Did the UAC actually receive only masks and gloves? Because it's not said.
Okay. So basically, basically a lot of our language basis in terms of names was we went to our Arthurian sort of legend sources, as I'm sure you can pick up at more secondary, and the basis was Welsh. But not spelled correctly, because as often happens in the Jessup, we try to sort of diverge from the spelling so that it's not that we are speaking in a specific language, but it is language inspired, if you will. Regarding the masks and gloves, this was something that we went through a lot. We specifically said in the problem that it includes masks and gloves. We were kind of hoping that the conclusion wouldn't be that they got masks and gloves and that's it, and that's the only safety equipment. We used that, and we weren't really intending that it would be only safety gear, which is clearly not sufficient, which is just masks and gloves. But it's also understandable that was the direction that it ultimately ended up going in. Yeah.
Good morning, authors. My name is Shashwat Singh. My question is with regards to the Claim A. So Claim A uses the term violation of the trilateral treaty in launching Operation Shining Star. What exact provision of the treaty were you envisaging? Because most teams seem to be turning first to Article 20, that use of force in self-defense against non-state actors in a leased territory. But the statement of agreed fact seems to use this phrase a lot, an act of aggression. So were you referring first to a violation of Article 2, Paragraph 2 of the Trilateral Treaty, or directly turning to the question of use of force in self-defense? Because if aggression, how will you characterize aggression under UNG Resolution 3314? Because both the sides seem to agree that there is an armed attack, but how do you first characterize a violation of the Trilateral Treaty? Do you turn directly to Article 20 or first to Article 2?
So the peace treaty refers to both the UN Charter and the principles on friendly relations. And the idea there was to ensure that you have enough breathing room to argue anything you wanted. We were not here to constrain your ability to only argue one way or another. We used the language of aggression in the problem itself when the parties were speaking, and so you can certainly describe this as an act of aggression and thereby use the use cogents violation for other purposes too, like in the sanctions context. But there's no question, and most teams went to a self-defense analysis and armed attack. And so the short of my answer to you is that we don't try to limit anything, or at least some authors do. We, as you're getting a sense, have not tried to limit your ability to argue anything and left it for you to argue it. And so just another way of dealing with this, I've heard teams, I see a member of the Oxford team here, who tried to push all this through the attack on the Emont violates Article 14, Article 14 of the Convention. And so why are we talking about Article 2 violation? It's all of our Article 14 only, and so, yeah.
We want to be able to give everyone a chance to ask a question, so if you could keep them brief, that would be helpful.
And we will do the same.
Thank you. I would like to ask, what's the inspiration of having a dispute in a leased territory, since we believe that it's rare in the real world? What's the intent or the inspiration comes from? Thank you.
Yeah, if the territory was not leased, then what is the context in which there is territorial activity that doesn't make Ragnall just a horrible human being or entity? That was the pushback we often got, that this needs to be balanced. One of the challenges in producing a good Jessup problem is that both applicant and respondent can effectively stand up there and argue something. The territorial leasing at least gave us some place in which Ragnall can justify what it's doing within a framework that was set out. So that was the core of it.
Please.
Good morning. My question relates to the fact that the POWs were moved to the northwest of Ragnall, and also that Article 28 of the treaty says within and surrounding the Geiss Peninsula. Everybody has had a different interpretation of this, so could you please draw the Geiss Peninsula so that we know how far the POWs will
So we have maps. We brought maps of the Geiss Peninsula.
Okay. They're available at the
table over there in the back. Now, a word on maps. A word on maps. So we drafted these maps and we had them as an annex for, now that everyone's rushing to go get a map. We had them drafted as annexes for this problem. The problem with a map is that once you give a visual articulation of the reality, students will see mountains and will go, oh, there's mountains, that must mean something. Yeah. And we don't want to have the entire thing be debated on the basis of this visual. But what I loved seeing, on Instagram you will find now multiple teams who have drafted their own maps, put them on shirts, created whatever, stories on Instagram with them. That is exactly what you should have done, and we loved seeing every single one of your visuals, even if we said, but it's upside down, what are you doing?
Please.
Hello. First, thank you for all the work you put into the problem. It was really interesting. I have two questions. One's very quick and one's slightly longer. The first one, perhaps following up on your interest in espionage, is whether or not you have a theory on how on earth Etna, this tiny island nation, got intelligence about the belt. And then the second one being with regards to the characterization of UAC, which was quite a complicated issue. Some argued it under the Fourth Geneva Convention, some under the Third, and even under minimum protections in Article 75 of AP1. I guess I'm curious if your intention was for them to be POWs, as that makes sense in large respect, but we also noticed that a lot of teams and even sometimes judges skipped over the first portion of that classification, which requires that the group belong to a state, and the commentary makes clear that that requires attribution. So it actually couldn't apply absent further facts. So I guess I was just curious what your intention was in the characterization in that regard.
So on Etna acquiring the necessary intelligence, you would be surprised how many island states have strong intelligence capacities. And I'll be happy to share more information after this panel. But the idea was a nod to espionage. So there were a couple of nods to intelligence. The other one was obviously the informant in the storyline, but that's because I cannot write a problem in Jessup without having some spying involved. To your second question, I think, as I mentioned before, we were trying to narrow it down to POW status. I think that AP1 allows you for more flexibility around POW characterization, and certainly this discussion around, even when you're uncertain, give them POW-like protections, allowed enough teams to go around any problems of classification, including that they potentially do not meet the fourth element because they violate international law in committing terrorist attacks. And so there was a lot to play around. We expected all that analysis to be part of it.
Thank you.
Good morning, Marco. I'm from the University of São Paulo. Thanks for writing such an interesting problem. Two quick questions. So first, that's something that bothered me every day ever since, and I would like to have some closure as well. So how was, we all know Aglovale refused to cooperate. That's okay, but how was Aglovale even supposed to receive the waste in the first place? The only land passage was blocked. Were they supposed to send it through, I don't know, Tindale Port and then into Oregano and then into Aglovale, and if so, why? And a short quick question. I believe paragraph 54 or 55 starts with, in light of the sanctions. But does it qualify only the following sentence, only the first part, or all of the paragraph? Can we or can we not attribute all of the effects of the sanctions to Aglovale? Thank you.
All right. Well, I mean, technically speaking, as a lot of teams tried as convincingly as possible to point out, the obligation to cooperate is not an obligation of effect. So I said, even though this main gateway had there was still an obligation to attempt. And I really, really admired the teams who really went all for it and said, no, there's going to be air possibility. They found ways to say, no, it's not an absolute impossibility. It was definitely a difficulty. I think when we were writing, we didn't think it was, for some reason, it just didn't occur to us that this would be as much of a thing. Of course, you know, how could you possibly continue to negotiate when the main thoroughfare has been obliterated? But considering—
One team effectively said to me that, well, they could have at least negotiated which island state to give the waste to. That I think is a good argument. And as for the other point, which was on the language, we wanted causation to be part of this. We felt like a lot of teams were struggling with causation even when we judged. So the language of that paragraph is precisely to give you enough maneuvering on how you argue causation with regards to the effects of the sanctions.
Oh, good morning. My name is Augusto. I'm from Brazil. On Compound Arden, I felt like there was a point that teams left aside, which was Ragnall's investigation on the matter. In the batch, we had not only Auskani versus United Kingdom from the European Court, also Mr. Lubin's Reasonable Intelligence Agency article, and both of them address the issue of when a mistake happens, there should be an investigation. Could you elaborate a bit on Ragnall's investigation on the matter that did not count with the victim's family participation, nor reach a conclusion on the legality of the matter? Was there a human rights law violation as well? I felt like there was a strong argument for applicant, but teams just left it aside.
So in 2011, when I participated in that drone strikes here, that was part of the analysis. There was an obligation to investigate was a word in the pleading. Was there an obligation to investigate, separate from the obligation to compensate? And so I'm really intrigued by what you're saying. I'll confess that I agree with you. I think most teams didn't raise it, and we didn't necessarily predict teams will raise it. But if I had judged you and you had said this to me, I would have given you a bonus point. I think that's really smart. I think that's great.
Hi, good morning. My name is Dhaval. I'm from India. So I have 3 questions, very short questions. Firstly, was it required to argue jurisdiction of the WTO GATT under Article 23 of the DSU? Secondly, the application of monetary gold, was it like necessary to be in issue 1 and 2, or was it for issue 4 as well? And lastly, when we look at the issue 4, which is about how Aglovale particularly did not negotiate per se, so was there a requirement of a material breach argument in terms of under the VCLT, or could there have been something else?
Wait a second, I'm sorry.
So on VCLT violations, I'll note that there's a lot of VCLT that you could have been thrown, and we expected to hear a lot more of it, including in the context of the applicability of treaties in times of armed conflict, at the ILC articles on that. There's like a whole preliminary, this is very odd for the bench memorandum, but there's a whole section of the bench memorandum called preliminaries. And we just anticipated a whole swath of types of things that students could try to say, that impossibility of performance, or that the treaty should be interpreted in particular ways in light of the armed conflict and so on. So that's on that. So material breach could be raised. How do you raise it while still giving the court jurisdiction? And severability might be an issue.
In terms of the monetary gold, I think we didn't really see the monetary gold as a central issue. We knew that it was something which was likely to come up, but we actually actively encouraged judges to keep the debate on that issue brief, because we were really more interested in getting to the substance. We believed that there was a strong case to be made for the ability of the court to hear the issues without monetary gold being an issue. And finally, the GATT, I think...
So it's in the bench, and that was Steven Schneebaum's favorite topic. Steven was terrified. This will become a trade law issue. And he kept pushing us on how to prevent this from becoming a trade law issue. I think, we were worried, on the day we released this, we were still worried about whether or not this will become a WTO problem.
Thank you.
Good morning. I want to know the intention behind the rhetorics of Van Votingen, because there was a time when I was preparing, I wanted to use it as an argument to say that could be a reason that we are not acting in self-defense due to his several rhetorics, and by virtue of paragraph 34 also, there are instances which other countries come in, they said, Votingen, they were not acting in self-defense. So what is the intention behind it?
I'm sorry, I just missed the opening. So what is which statements product here? Sorry.
Van Votingen saying doubting whether the treaty is in their best interest.
So I think that where this plays out is in the necessity analysis, because a lot of teams ask the question, was this last resort in the light of the Webster Declaration? The no choice of means and no moment for deliberation. And there is a choice of means. You could just announce tomorrow that you will withdraw from this belt tomorrow. And had you done that, the UAC will pull out. And then students push back. No, they wouldn't. So that was certainly part of the analysis of the self-defense and armed attack claims.
Thank you.
Sorry, I missed that.
Hi. I was just wondering, what is your evidence regarding opinio juris about the Basel Convention that parties to the Basel Convention are complying with it, notwithstanding their treaty obligations? And also, how is Stockholm relevant in any way?
Oh my.
Yeah, go for it now.
I can't wait for you to get the access to the bench memorandum, because there's a whole discussion of Stockholm that we never got to have play out. There are pedagogies, and there's ways to apply the Stockholm Convention, and that's why it's not merely plastic waste. It's plastic waste that's contaminated. And so I'll be honest with you, whenever you engage in any subject matter specific area of expertise, you're worried, because we have, and Shannon certainly has an understanding of environmental law, but then you never know how these things play out, especially when you get to the science of things. And teams brought out WTO reports WHO reports, World Health Organization reports that we never heard of. And so including all these treaties together was an intentional thing to give you, again, maximum flexibility. We do think that there's a legal argument around Stockholm, and we consulted with a professor from UC Berkeley, who specializes in contamination and wastes management, on how to phrase that particular thing.
And the professor emphasizing that this is a very sort of fluid field, that there's a lot of room for different
standardizations that come in the expense of hard law sometimes. But also on they're not parties, they are parties. That was intentional. We wanted there to be a customary analysis, and especially a customary analysis of the plastic amendments, which only came to effect in 2021, sorry.
Okay, and the evidence on the Basel Convention, like notwithstanding their treaty obligations, is there specific evidence that we should have used for the Basel Convention being CIL?
Well, again, more or less specifically concerning the analysis regarding the large number of states which are already parties. There was the persistent objector also, which basically never came up. We thought there was a certain claim to be made for Ragnall specifically as a persistent objector to the...
Good morning. My name is Felix, and I have 3 questions, but I'll try to keep them brief. So first, I would like to know about the wording of the pleadings. So in the pleading of the applicants, we actually say the employment of the UAC fighters as well as detaining them. In the respondent, they actually say temporarily employing them and also transferring them to the Clarent Correctional Center. I'm just wondering if there is any meaning behind the distinction between the use of words. And also, I would like to ask about the remedy, because among the 4 issues, the second one, which I heavily rely on, will be only regarding the illegality of the actions taken by Ragnall, rather than asking them to do anything. Like reparation or any cession of anything. So I would like to know if there's anything behind it. And the third one would be regarding the prisoner of war. So you mentioned that you wanted the discussion to be revolving around prisoner of war. However, according to the batch materials, there are a huge literature on the 4th Geneva Convention. And I think many people are thrown off because I saw a lot of memorials that are actually heavily regarding the 4th Geneva Convention rather than the 3rd one. So that would be my question. Thank you.
And we all asked, because there's a long line of you, and we're already at the time, we're going to take a couple more minutes over, but we want to get to as many of you as possible. So if you can pick your one question each. So every time we add a remedy, we're adding more time to talk, and that's a problem. And so you pick your battles with remedies. We cannot do a lot of remedies and address a problem. So there was a couple remedies, but really a lot of it was just declaratory relief. On your first question, now, Luthi.
Yeah, me too.
Yeah. Well, I'll come talk to me afterwards.
Okay, thank you.
Morning. I'm still curious about the interaction you guys envisaged between the incorporative elements of the treaty and the standalone obligations entailed therein, specifically whether or not Article 20 could override the Article 15 obligation to protect Nantes Gateway, especially given that IHL doesn't really preserve a right to bomb military objects. It just doesn't contain any express prohibitions to do so. I know we've had this debate before, Asaf, but I'd like to hear any additional answers if I could.
So we had this discussion in a round, and as I told you in that round, afterwards in the feedback, is that the right hill to die on? And I still don't know if that's the right hill to die on. So we created Article 20 to ensure that no team can just say there was a breach and the breach kills the entire treaty. And so we wanted to make sure that there's an ability to still justify the actions within the treaty framework. So that was the logic. Now, you push back correctly that maybe it doesn't do that Article 20 doesn't solve your Article 14 or 50, whatever violation. I think that's interesting. You were the only person I ever heard argue it. You did it very effectively in the round, but it's new for me. So yeah.
Thank you.
Yeah.
Hi, good morning. My name is Laura Marques. I'm from the Federal University of Uberlândia in Brazil. And I'd like to ask a question regarding the sanctions. As I was researching the sanctions and everything, since it is such a broad pleading, we can talk about human rights and other impacts the sanctions had. Sometimes on the rounds, there was enough time, as you already said, to talk about the effectiveness of those and the legitimacy politically of those sanctions, since we are here regarding about the law. And what all of you thought about how the Jessup and the International Court of Justice can contribute to this discussion, specifically like on last week, there was the publishing of the certain Iranian assets merits phase, and there is still the pending decision on the alleged violations of the 1955 treaty. So there is a vacuum here, not only on the debate politically, but also on the law. And how do you address that, and how do you think that in the future, if there's going to be a consolidated matter?
That's a great question. So I'm sorry to cut you off.
No,
we're very mindful of the time. That's the only thing. We're doing time management too. See, I'll briefly answer that. One of the things authors love to do in Jessup problems is to create conflicts for pleaders, where at one time you want to argue one thing, and the other time you argue the exact opposite. So in the first part of the sanctions, you want to say that they're non-coercive and therefore that they do not violate the principle of non-intervention. And you do so by saying, oh, they are at other means. And look, he said that he could negotiate and trade with his partners. But then later, when we get to the countermeasures argument, effectiveness is an element in proving the legality of the countermeasure. And that now forces you to say, oh, they were very strong and very impactful. That clash was intentionally built into the problem.
Thank you.
Hello, my name is Roshan Nepal.
So
I am from Nepal Law Campus, and I have two precise questions. In internationalizing the armed conflict, did you want us to rely on Article 1.4 of the Additional Protocol 1 or the common Article 2.1 of the Geneva Conventions, because the threshold to meet Article 4.1 is very high? That is my first question. And the second is precisely related to the fourth issue, because by virtue of Article 4 of the VCLT, we cannot rely on suspension or termination of the treaty. And did you want us to rely upon other possible means, for example, the exceptio of non-contractors?
Yeah. So I just want to repeat what Steven said. We're only going to take one more question, but all of you stay in this line. We'll just come down and we'll keep talking to you, okay? They just need to set up for the actual big thing, which is the international round, final round starting. So I'll just take the question on the POW status because of time. As I mentioned before, our hope was to focus it on AP1 and the framework set out in AP1 through that Article 96 declaration. We heard teams do an Article 1 analysis with the limitation of the high threshold that it sets, and it's problematic, as I think you're indicating in your question. And so the Article 96 was a way of alleviating some of that concern. But even if you don't argue POW purely, you argue them as protected persons with POW-like protection, you still get around some of that problem.
Okay, last question from the floor, and then as Asaf said,
greetings,
continue the
I'm
conversation.
from China, and I have two small questions. Firstly, regarding the law enforcement, and we've discovered there were various norms that, such as police personnel and military battalions and military personnel, and as well as military campaign operations. So concerning this problem, were you intended us to discuss about the distinction between police personnel and military personnel, or the law enforcement activity and the military campaign?
So I'll take just that. I know you have another question. We'll talk about it after. I'll take this one because it's a great one. Deborah Whitus is a professor at Indiana University Maurer School of Law. She's one of the preeminent scholars in the country on statutory interpretation. And a Maurer student who participates in the Jessup presented this entire argument, and she shut him down really quickly. What do you mean? It's very clear that this does not apply to military, it only applies to police, and that you cannot describe them as police. I like that argument. I thought that it's very creative to talk about functions. What is military functions versus police functions? And especially in occupied environments, there is this bleeding of police activity, law enforcement activity, and military. So that was intended, but you see there's people who have been experts who disagree with whether or not that's right.
So the conversation can continue, as Asaf said, but it's going to have to be offline, as it were, because this room has to be prepared for what will happen this afternoon. Since very few of you, perhaps almost none of you, have actually attended a final round in person because the last one was so long ago, let me remind you that when the judges leave the courtroom to deliberate this afternoon, the current chair of the board of the International Law Students Association will read out a 2 or 3 sentence, that's all, 2 or 3 sentence description of the 2024 Jessup problem. So you will all have that little taste dangled in front of you. And let me tell you one other thing before I adjourn the meeting, and that is this. As you may have realized, there is a lot of lore and tradition and history that goes into the Jessup and goes into the Jessup problems. For example, you've all noticed that there is always, in the Jessup problem, an organization whose initials are ILSA, for ILSA. That's obvious. But what you may not have realized before is one problem that authors often have is sourcing. What is the source for the factual statements that the students are meant to take as given without quibbling over whether they're established or not established? Well, media, right? Newspapers. That's not great, but it's as good as anything we can come up with. So what newspaper will we use? Well, you may have noticed that this year, I assume you all noticed, that this year's newspaper was the Boston Globe. Why was it the Boston Globe? Because the Jessup tradition is that the newspaper quoted in the compromis, or the problem, the statement of agreed facts, is the hometown newspaper of the team that won the cup the previous year. And last year the winner was Harvard, and therefore Boston Globe.
Now, we were playing with Crimson. We decided not to go too much in.
That was over the top. Anyway, thank you all for coming. Continue the conversation by all means, but let's have a round of applause for these authors.